The first thing that ESTA does is monitor the implementation of new EEA legislation. Why is this important? Well, if you're a business and you're working in Iceland and you're wanting to export, you want to know that the legislation that Iceland has on its statute books is correct under the EEA regime. For example, if there's a regulation that Iceland hasn't implemented, you know less where you stand as a business. So one of the really important roles is to make sure that the member states implement all this new legislation that Odo was just talking about. How do we do that? Well, we have the carrot of being extremely pleased by internal market scoreboards. And when we have member states who improve their compliance rates, we'd like to make a big song and dance about it and praise them. Similarly, this can sometimes be a scoreboard of shame for a member state which is being a bit slow about complying with its duty to implement the directives and incorporate the regulations. So we track and monitor and publish in order to make sure that the member states are strongly incentivised. Of course, sometimes it's a bit complicated and there's lots of different reasons. When a member state isn't implementing a regulation, say, it might be because they are just running slow. It might be because there's something very controversial going on in their parliament. It might be because they have linked that piece of legislation to a whole package of reforms and the whole thing has got stuck on another point. Or it might be that actually there's a problem with the regulation. So what we tend to do is we get talking to them. Sometimes the Secretariat comes into that conversation, quite rarely, but occasionally. And we try to make sure that this thing sort of moves forward as quickly as we can get it to move forward, because this is kind of the bedrock of making sure that there's compliance with the EEA legislation. The next thing that we do is, once that the legislation is actually on the statute books, we make sure that it actually works. So that's in several different ways of checking on that. So, for example, we try to make sure that the member state has actually implemented the directive or regulation correctly. Now, regulations are supposed to have direct effect in the EU, so what the member states tend to do is publish a law saying this regulation is now part of, say, Icelandic law, and then you just look at the regulation, nice and easy. Directives, it's a little bit more complicated because the member states are supposed to create national legislation which implements the directive. And in that, you sometimes get more choices. And when you have choices, you have the need to make sometimes conformity assessments. So what we do on occasion, particularly when we've got a great big framework directive that's going to be super important, we send a letter to the member states asking for a conformity assessment. And the member states really, I am informed, totally love this exercise of looking paragraph by paragraph at a whole directive and providing details paragraph by paragraph of the national legislation that implements the directive so that we can sit together and scrutinise it. We don't do this on every piece of legislation because it's very, very work intensive, but where we have an important piece of legislation, it's really important to know that the compliance is actually being generated, so the national legislation is in conformity with the directive. And I have had lots of fun discussions about various aspects, for example, of the lifts directive. I've become an expert on lifts, and in particular lift braking systems, where there's a discussion. Now, actually, one of the interesting things about working in ESTA is that you get to see how terribly drafted some of the EU regulations are and the EU directives are. Sometimes you end up in situations where there needs to be some legislative ambiguity in order to get all the member states to actually agree with each other. But the problem is that when you're looking at that from a compliance perspective, often there's a very legitimate difference in interpretation between ESTA and the member state, and, say, Norway and Iceland, or Norway and all the EU member states. So a lot of this involves quite a bit of brain work. It's not just kind of, have they done it, tick the box, move the piece of paper to the other side of your desk and move on. There is some quite serious brain work that does happen. So, yeah. So that's the kind of the first way of investigating. So we do conformity assessments, and we check that what is on the statute books is in fact actually reflecting what is supposed to be there. But that's of course not the whole picture. And the next bit of the picture is, okay, you've got your law on the statute books. So for example, consignments of dangerous goods in Iceland, police checks on consignments of dangerous goods. There is a law in the EU, which is now part of EEA law, saying this kind of consignment of dangerous goods ought to be checked regularly on a regular basis and reports sent to EFTA. Now, I really like regulations and directives which specify that you have to send a report, because when the member state fails to send that report, it tells us that probably something's gone wrong. So it's very helpful in order for us to investigate a little bit further. In this particular instance, the consignments of dangerous goods, we saw that the law was all in order, but there weren't any checks being carried out at all. And so that led to about a year of discussions with Iceland to find out what had gone wrong there. Why is this regulation on the statute books, but nothing's happening on the ground? Because in the end, what we're not concerned with is checking that everybody's statute books are absolutely perfect. We're actually, that's only one part of a bigger picture. Okay, and the bigger picture is that people within the EEA EFTA states are actually able to take advantage of the EEA law, right? So you need to have things not only on the statute books, which is also a good thing and a necessary thing, but also happening on the ground. So this is a really important part of our work as well. We also, so that's kind of the own initiative side of things. So we look into things systemically, and we look into it on our own motion. But we also take complaints. Anybody can complain to ESSA. Please do send me your complaints today. And anybody can file a complaint if they think that their EEA rights might have been infringed. So some complaints are a little bit sort of tangential. Some of them are very, very solid. And occasionally we have groupings of complaints, which is quite a good indication that something in particular is pretty important. Now we look into all complaints, particularly in the internal market side of things. Then all complaints get investigated, and we decide whether there's a problem. But we don't act on behalf of a complainant. So ESSA is not a body like kind of a watchdog body. What we do is we take the complaint as an example of a problem with EEA law in a member state. So we see it as a compliance problem, and then we go after the member state on behalf of the EEA agreement, which sounds a bit pompous, but not on behalf of the complainant. Okay, so we're not a legal service for the complainant. We are trying to ensure compliance with the EEA law. Now, how do we go about doing that? Well, firstly, we send off a letter, can be a request for information, can be a friendly inquiry, we might pick up the phone, talk to our counterparts at the ministries in the member state, and if we're satisfied that there isn't a problem, we'll close the matter. If, however, there is a problem, we go into the formal investigation procedure. And this is set out under Article 31 of the Surveillance and Court Agreement, so I might refer to it in passing as the Article 31 procedure. Firstly, we send a letter of formal notice to the member state. Well, actually, firstly, we send them a letter warning them that we think that there's a problem and that we're thinking about sending a letter of formal notice, so that they get the chance to kind of go, no, it's okay, we'll correct this particular piece of legislation right away, don't send a letter of formal notice. But if they don't fix the problem, and we think that there's a problem, then we send the letter of formal notice. And if they still don't fix the problem, then we send a reasoned opinion. Letter of formal notice is kind of what it says on the tin. It's a notification that we think that there's a problem and that we want to do something about it, and the something might be taking the member state to court eventually. Then the reasoned opinion is where we formally set out what the problem is, what they need to do about it, and it forms the basis for a potential court case. 2 months to reply to the reasoned opinion, and if the member state hasn't sorted the problem out in 2 months, then we have the grounds to take them to court. Now, the EFTA Surveillance Authority sees the court as one element in the toolbox for compliance. So sometimes you can get a better result by sitting down and talking to the ministries that rather than taking a country to court and then getting a judgment against them, and then they still have to do something about that judgment in order to come into compliance. So there are lots of different ways of moving a country towards compliance, and that is really our focus, and that's the contrast between us and the court itself, which obviously focuses on what has happened when you have reached the stage when you're in litigation. And sometimes you're in litigation and it is adversarial, but it's kind of about thinking about how to interpret a particular element of the legislation. Like I was saying earlier about the legislation which can be poorly drafted, there actually we've had a couple of cases where we've taken a country to court more almost to find out what the correct interpretation is, because that's the court's job, in order to make sure that everybody is clear. And in those cases, we're advocating a particular answer which we think is correct, which might not be the same answer that the member state is advocating. But in the end, what really matters is the clarity that you get at the end of the court process. So we all remain friends. Okay, other things in internal market, just very quickly want to touch on inspections. These are the super fun parts of working in ESSA, and I've been lucky enough to be part of the transport unit for 2 years during my time at ESSA. We go off on inspections looking at safety and security in maritime ports and airports. And we look for food safety, so we inspect slaughterhouses and restaurants and treatment processes. And the interesting thing to kind of take away from that is that is not really on-the-ground inspections of ESSA swooping in from Brussels to your country and going, oh, this restaurant is rubbish and has rats running around, you need to close it. No. What we're doing is inspecting the food safety authorities and the transport authorities in the member state, and so they kind of pick a particular restaurant or a particular maritime port, and they show us what their processes are for generating their security. So we work hand in hand with the national authorities. And ESSA works really quite closely with lots of different national authorities. So we work with the Rail Transport Union, we work with the competition authorities in the member state, we work with the transport authorities, we work with the food safety authorities. So lots of different little points where there's an EU law or an EEA law aspect to your job in the national framework, you can find yourself working with ESSA. Which then improves sort of knowledge and cooperation and makes compliance better, and it makes the on-the-ground compliance better as well. Okay, going to touch on the other directorate now, state aid. Those of you who are interested in state aid probably know everything about the content of this slide already. Those of you who aren't probably don't want to know about the content of this slide. So we monitor state aid in the EEA. That's a lot of processes, mostly generated either by notifications or pre-notifications or by complaints. We analyse the state aid rules and check that particular situations are in compliance. Our state aid cases range from the extremely small, so we've got some sort of very small municipal cases, right up to the very, very large, such as carbon capture and storage, which is a notification which is coming in fairly soon, or has already just come in, just after the summer. The idea is that state aid is, of course, not permitted because it distorts the market, but obviously there are some exceptions, and ESSA's job is to analyse those exceptions. And in that, we work with the national authorities, we work with the complainant and the businesses to try to make sure that we have a good economic assessment and a good legal assessment of what's going on, and then we make our decisions. And in the end, what we can do is we can decide that there's no aid, that it's existing aid, we can decide that it's aid but it's fine, or we can decide that it's aid which is unlawful state aid, and then we can order things like repayment of the aid. So ESSA's powers are pretty extensive, and they're more or less the same as the Commission's powers in that field. And also that's kind of logical because the law is the same in both fields, so it's the same rules being applied, and you can understand why, because the point is that you need to keep the internal market fair and balanced. On the competition side, same story. So we enforce the EEA competition rules, 53 to 60 the EEA agreement, Protocol 4. And we look mostly at agreements between undertakings and instances of abuse of dominant positions. We've got 2 competition investigations going on, which of course start with the very dramatic Dawn raid and then involve processing and looking at thousands and thousands of emails and pieces of paper and bits of business information in order to figure out whether there has been unlawful competitive behaviour. So at the moment we're looking at an airline and we're looking at a telecoms company looking for that. And there you have all the same processes that you would expect to find at the Commission. So you have your statement of objections, hearing, you have the decision, and then the court procedure as well, which is pretty normal in competition. So that's what ESSA does in competition. And then that brings me on to my own department, which is Legal and Executive Affairs. Like I said, we do lots of different things, mostly legal reviews, so we check that everything is watertight and well argued. Basically, that if it came to court, would we have a good chance of winning it? That's kind of the test that I apply when I'm looking at my colleagues' work. And then we provide executive support to the college, so we do things like speech writing and external relations, and we do various analyses of what, politically speaking, where we ought to be paying more attention, for example. I mean, ESSA is not a political body in the same sense that the Commission is a political body, but we do operate within a political sphere, and so we need to pay attention to the politics. And then communications, so we do press and outreach work. We have some outreach projects such as an EEA law summer school, which runs every summer. That's an intensive week of study and you learn everything that you could possibly want to know about the EEA agreement. And we do a moot court, so we reach out to universities and we make sure that we have a lot of good contact with students in order to show them how brilliant EEA law is and how much fun it is. And then, of course, the Legal and Executive Affairs team does all the court work and litigation. So when we end up in court, it's several different things. It's interpretation of EEA rules is generally the focus of any particular court case. And without wanting to tread too much on the toes of somebody who actually works at the court, we have kind of 2 different types of cases. We have the direct actions, which is either when we're bringing an action against a member state or somebody's trying to get one of our decisions annulled. And then we have advisory opinions, which are the references from the member state courts, which are asking for clarification on a point of EEA law. ESSA also does work in a few other courts. In particular, we sometimes provide amicus briefs in the national courts, so to help kind of the national court clarify its thinking on a particular point of EEA law. We've got an Icelandic case going through at the moment. And then because EEA law is EU law and a lot of EU law is EEA law, we intervene at the Court of Justice, occasionally at the General Court, on points which are actually of relevance to the EEA and the growth of the EEA legislation as a whole. So lots of interesting court work, and I'm very lucky to also be dealing with a case that's in the Strasbourg court at the moment, where we have a complaint against Norway about the EEA agreement and potential infringements of Article 6. So we have submitted a amicus brief in that as well. So lots of interesting court work and a very fun department to work for. So that's basically ESSA top to bottom. I hope that you're all still awake. I'm super happy to take any questions, but are we going to have a talk about court first?
Are you available?
I'm happy to stay.
Yeah,
no problem at all.
Yeah. So. Yeah, so I know some of you definitely have some questions, but I think it makes sense to maybe take the questions after we have had the court, because it was even part of your presentation. So it goes hand in hand, and it could be a better Q&A session. So last presentation before lunch is from the EFTA court. We have Birgir Hrafn Búason, who is from the EFTA court in Luxembourg, and let me see, here you are. and then we do the Q&A. And
hello. My name is Birgir Bosen, like already mentioned. I'm a senior lawyer administrator at the EFTA court. So I'm one of those lawyers trying not to mess up the administration, I guess. No, but I handle the procedural issues at the court, more or less the timeline. I'm the person who tries to make sure that all the trains run on time, so to say. And I'm here to speak about sort of the next step, I guess, in the process. What happens when people don't agree? What happens when the states don't implement or don't implement correctly and can't agree, and everything else has failed, and the matter ends in litigation. So I'm going to try and divide it into sort of three major topics. I'm first going to go over the legal framework, and then the relationship between the EFTA court and the EU courts, which is of course important since we're interpreting the same law. And then I'm going to go a little bit over some notable case law, obviously not everything. I'm going to try to focus on things that are EEA specific, and not sort of the general sort of run-of-the-mill cases. So the legal framework, like already mentioned by Kat, like some of the things that I will deal with that have already been mentioned by Kat, but we have this framework set up. It starts with the EEA agreement, of course, that according to the agreement, the states shall establish a court of justice, which they obviously have. Then the EEF states made the surveillance court agreement, and that sort of establishes the main rules, the ground rules for both the EFTA Surveillance Authority and the EFTA court, and a protocol to that agreement is the statute of the EFTA court in Protocol 5. And then, of course, the court has its own rules of procedure, which are currently under review, but it's sort of most of the main rules about the court and how it functions can be found in mostly the statute and the rules of procedure, but of course there are some sort of rough general rules in the surveillance court agreement as well. So the court has 3 judges, one nominated by every EEA EFTA state. Of course, the judge does not have to be from that state. For example, the former president of the court who recently left, he was the Liechtenstein judge, but he was Swiss. So there's no. So we have our first actual Liechtenstein judge at the court now. And like ESA, we always welcome more Liechtensteiners. We had our first Liechtenstein, I think it was 3 years ago, that we had actually our first person from Liechtenstein working at the court, and it's sort of at the point 23-year history. And that was a trainee. So always welcome more. So there's one, the court is organized into cabinets, one cabinet for each judge. The cabinet has 2 legal secretaries and an assistant. And then we have the registry, which handles both the procedural issues, which are on my table, and the administration, and then, of course, as well as general administration, finance, HR, so on. But we are even smaller than ESA, way smaller. We are only around 20 people. So court is extremely small. Our working language is English. And we try to keep the duration of our proceedings as short as we can. It is currently, the duration of the proceedings is currently around, the average is between 8 and 12 months, around 8 to 11 months for advisory opinion proceedings, and between sort of 9-12 months for direct action cases. But I'll go over those sort of procedures in a little bit. Yeah, so the types of cases, like Kat already went through, we have the direct action cases, so that are divided into 2. First of all, we have the infringement actions against EFTA states that haven't implemented or haven't implemented correctly EEA legislation. those are normally initiated by ESA, but can be initiated by another EFTA state or an EFTA state. This is similar to the EU. This hasn't been used, but this has been used in the EU. It happens very rarely, because this is, of course, a diplomatic kind of a nightmare, especially when you have such a small, tight-knit community as these three states are when it comes to the EEA agreement, that even if you have a situation where EEA law has been implemented wrongly, or in one state believes that it has been in another state, and it's affecting the rights of the citizens of that state, for example, there's a problem in Iceland and the Norwegians are being affected by it. Normally, the Norwegian government would just wait for ESA to do something about it, rather than to take the case themselves and create like this, create this diplomatic incident, I guess. And then we have the other main the main direct actions are challenges against ESA. So more or less somebody who challenges the validity of an ESA decision, or ESA's failure to act, or the liability of ESA. But normally it's the Article 36 procedure on the validity of ESA's decision. So the direct actions, the infringement proceedings are modeled after Article 258 TFEU, but unlike the EU rules, the court has no possibility to issue fines in cases where infringement is found. So more or less, it's always just a slap on the wrist, nothing really more. But of course, once you have a court judgment which stating that you are infringing EEA law, it is of course in the best interest of the state to fix it, because it might jeopardize the EEA agreement, which we are also very fond of. So normally the judgments are followed and things are corrected, even if we can't impose fines. There are a lot of cases that are brought under Article 31, and most of them are so-called sort of rubber stamp cases. Of course, there are some where there's a proper dispute, but a lot of them are more or less just the state is already sort of so we had a lot of them in let's say we had a lot of them after the crisis in Iceland, for example. After the crisis hit, there was the Icelandic administration was downsized dramatically. I was sort of shortly thereafter, I was working in the Ministry of Foreign Affairs, and from 2009 to 2015, the Icelandic Foreign Service was cut down by around 30%, and that was like that with a lot of other ministries. So at that time, Iceland had a huge sort of backlog of EEA legal acts that hadn't been implemented, which caused a lot of these cases coming to the court, these non-implementation or these infringement cases, but it was actually just that they were sort of, it was just at the back of the line, and when ESA brought the application to us, the defense, it was normally just, yeah, sorry, we know it will be corrected in 6 months. And so that's not really a case. So we had a lot of those, but of course there are more serious issues where there is actual disagreement. There's a disagreement on how to interpret the legal act, and therefore how to correctly implement it. And then we have, of course, the Article 36 procedure, which corresponds to Article 263 of the TFEU, which is about challenging ESA's decisions. In practice, these are mostly just about challenging ESA's state aid decisions, almost entirely. Private applicants can challenge these decisions, but the standing rules are very, so it's difficult, or they're very strict. Or the court has applied or interpreted those rules, applied them similarly to the ECJ, meaning that it's very difficult for private applicants to challenge these decisions without them being actually directly affected by it. Then we have the second type of cases, the advisory opinion procedure. So more or less, this procedure is similar to the preliminary reference procedure, in a way that national courts of the EFTA states can ask the EFTA court a question or questions concerning the interpretation of EEA rules and law. So any court or tribunal in any EFTA state can ask a question, and it should ask it when that court or tribunal considers it necessary to enable it to give its judgment, obviously. They are not formally binding. Unlike preliminary references in the European Union or preliminary references of the ECJ, and they are not formally binding, but they are normally followed. I say normally. So, like I said, the Article 34 is modeled after the corresponding Article 267 in the TFEU. They are not preliminary rulings, and like I said, it doesn't matter really whether they're binding or not. But yeah, a little bit. Like even if most of them are followed, we have these fringe cases. For example, the STX judgment from 2011, and or in case 2011, and then the Fosen-Linjen case in 1616, where the referring court just decided completely just to say like, yeah, we hear what the EFTA court said, we just don't agree, and we're not applying. We have had several other cases where the court reached a different, outcome, or that it was just not really in line with or in accordance with the advisory opinion of the EFTA court. But let's just say they weren't as blunt about it as they were in these two cases. And sometimes the courts can even they just choose to solve the case on different sources of law, constitutional law or their own national law, and just try to circumvent the interpretation of the EFTA court if it doesn't fit. Obviously, like I said, these are few cases, fringe cases, but they exist. So actually the binding nature or the non-binding nature of it actually matters. And for example, in the Fosen-Linjen case, that was the appeals court in an appeals court in Norway that disagreed, and then that case got appealed to the Supreme Court of Norway, which then due to this conflict decided to refer the case again to the EFTA court, seeking clarification of its earlier judgment, and that was case E718, second Fosen-Linjen case. The EFTA court has already delivered its advisory opinion, but the Supreme Court proceedings are still ongoing. Another big difference, which might be even more important, is that there is no explicit duty on courts of last instance to refer. So, courts in the EFTA countries are more or less free to choose whether they request an advisory opinion. For example, this was dealt with, for example, in EFTA court case 1811, Irish Bank, where the court stated that that there was in particular no obligation on national courts to request an advisory opinion, but they are of course bound to fulfill their duty of loyalty under Article 3 of the EEA. So there's this indirect obligation to refer questions, but there is no, it doesn't constitute any breach. ESA would never bring a case against a member state just because they see that a court didn't refer. So let's just say it's it's a bit loose, this obligation. Yeah, in case 312, the court also stressed that that is very important for all the courts, all the national courts, to obviously refer if the situation lacks clarity, because of course you're not referring, dealing with it on your own. It doesn't ensure the same homogeneity both within EFTA countries, and of course the entire EEA area, and the entire 31, maybe soon to be 30. A little bit about the relationship between the EFTA court and the EU courts. According to Article 6 EEA and Article 3 of the Surveillance Court Agreement, the EEA agreement is to be interpreted in conformity with the relevant case law of the ECJ. This is very important. Obviously, we're dealing with the same law, and it's very important to ensure this aforementioned homogeneity, that the law is interpreted the same way on both sides of the, in both pillars, so to say. There is, however, sometimes a difference in scope and purpose. And of course, you need you need to look at things with put on different glasses when you sometimes are interpreting rules that are slightly different, or where the EEA agreement has a slightly different purpose than EU primary law, sort of the corresponding EU primary law. And then we, of course, also just have very specific EEA problems, like Kath was mentioning, sort of what's in, what's out. And we have, for example, the marine harvest case, which was a state aid case, which related to the fishery sector, or the fish farming sector, to be more specific, because fisheries and fish is obviously outside the EEA agreement, and they were sort of claiming that ESA had competencies to sort of deal with state aid in that sector, and brought the case before the court. Then there's another problem. That is that since we are smaller, and our proceedings take a shorter amount of time than that of the ECJ, almost around, I think around half of the time as ECJ proceedings, the EFTA court very often has to deal with questions of law which haven't been dealt with by the ECJ, which sometimes poses a little bit of a problem. And then there's the question, what happens in those cases? Normally it's not a problem. Normally the EFTA court just deals with it, reaches a conclusion. Then when the ECJ deals with it, usually reaches the same conclusion, the same interpretation, go for the same interpretation, and it's not a problem. But it has happened that we deal with the case, we have a judgment, then the ECJ deals with it, and it's like, nah, it's not really how we think it should go, and they deliver a completely different judgment. And then a similar case comes back to us, and what does the court do? Do we follow our own precedent, or do we follow the ECJ? And what we do is that we follow the ECJ. So we abandon our own precedents if it's not in line with ECJ case law. Yeah. Like I said, we need to ensure homogeneity, and the homogeneity principle is more important than sort of ensuring that we are always consistent in our interpretation. But the EFTA court has been relatively frequently cited by the EU courts and their advocate generals, and you can see a few examples of where the EFTA court case law has been cited. A little on notable case law. This is probably the most important judgment of the EFTA court. It's case 997. It's a Sveinbjörnsdóttir case. It's established state liability in EU law, or EEA law. The reason why this is important is because state liability wasn't written directly into the agreement, and state liability is a lot more important in an EEA context than it is in an EU context. And that is because we don't have direct effect and direct applicability. So private individuals cannot claim any right before national courts if it hasn't been implemented into national law in the EFTA states, unlike they can do in the EU. Which means that their only avenue to get something, even if they don't get the rights, is to get compensation. So this judgment established that, and is sort of the small little safeguard that we have when it comes to non-implementation or poor implementation. Another EEA specific topic is relates to the Citizenship Directive, because the Citizenship Directive is laid down in Articles 20 and 21, or like the citizenship concept is laid down in Articles 20 and 21 of TFEU, but of course we don't have the corresponding articles in the EEA. So because the EEA agreement hasn't changed, it has remained the same now for 25 years, while the EU treaties have changed. The problem is that the Citizenship Directive was deemed EEA relevant, despite us not having these treaty articles, and was incorporated into the agreement without any adaptations or substantive adaptations, which meant that we suddenly had secondary legislation which lacked the primary law sort of backup that it needed when it came to it being implemented and interpreted. This raised, and is still raising, complex questions, which were dealt with, for example, in these two cases, Gunnarsson 2613 and the Yappy case, which is 2815, and we have another one, the Campbell case, which is currently, we received this summer and is currently being dealt with by the court. For example, in the Gunnarsson case, it was an Icelandic pensioner who moved to Denmark with his wife in receipt of unemployment benefits and was not allowed to use his wife's tax allowance. So this was, but the thing is that the problem was that the ECJ had dealt with similar cases, but they always dealt with those cases on the basis of primary law. They used the treaty articles to clarify the case and give the rights. It didn't rely on Article 7 of the directive, which was sort of what was being claimed in the Gunnarsson case, or like the Gunnarsson case was based on. And the question was whether a person could, even if this had been solved through primary law in the EU, if you remove the primary law, can you get the same rights in the EEA by just relying on the directive, which sort of the ECJ had not gone for. And yes, said the EFTA court, more or less. So the thing is that if the EFTA court had not gone for this interpretation, that would have meant that a Norwegian moving to Sweden would have different rights than a Swede moving to Norway. And like I said before, Gunnarsson decided, the ECJ had more or less reached the opposite conclusion of what rights could be based on Article 7 vis-a-vis the home state. So this was a very unusual situation. The Yappy case, more or less just this more or less similar question was asked, and the court came up with the same answer. And like I said, now we have a third case in which we have same so. The court has been accused a little bit of judicial activism, sort of implementing treaty changes through the back door. So in the way that the EFTA states didn't, they decided not to, of course, even though that would be extremely difficult, they decided not to change their primary law or make any sort of substantive adaptations. But the court sort of did it for them. That's what many people say. But the problem is, of course, that by incorporating the directive without making any substantive adaptations, this sort of gap was just left for the court, and it needed to be dealt with somehow. So I don't think there was maybe a right or wrong solution in this. And then also we have the import of meat. Like Kath mentioned, we agriculture is outside of the is outside the EEA agreement, and agricultural products. but they are still covered a little bit. The problem is that the legislation relating to food and feed safety is part of the agreement, even if the agricultural products are outside. So it's like a little bit of a yes and no situation going on. And we had two cases from Iceland. First, we had an advisory opinion case, 1715. Prosecutor, where somebody just more or less, Iceland had a licensing system, where they needed as related to veterinary checks. It was more or less that meat imported to Iceland had to be frozen for a certain amount of time before it was imported, so the ESA had already started the proceedings against Iceland, not direct court proceedings, but an Icelandic company didn't feel like waiting for it, so they just imported some fresh steaks to Iceland. They were seized by customs, and then they went to an Icelandic court, claiming damages, and requested an advisory opinion from the court, where the court stated that this scheme, this license scheme that Iceland had, was in breach of EEA law, but then Iceland didn't change their legislation, so ESA needed to bring their case anyway, and amazingly enough, the EFTA court reached the same conclusion in the same case. Just at the end, since I know everybody's dying to get some lunch, it is here of just a few interesting cases in case anybody feels like looking at some or like is a law geek, like as mentioned, it feels like reading some EEA or EFTA court judgments. These are a few cases that are quite important. And apart from that, just I thank you. And
so thanks to Birgit as well. And we have a few minutes before the break for lunch. I'm sure you're all hungry and you want to get fresh air as well, but let's try to get some questions before. It can be to ESA or to the EFTA court, or to both even. One over there, Andorra.
We'll just come and join you.
Yeah, exactly.
Just a question for the ESA colleagues. Are you also investigating the official bodies that they are on the member states, the responsibility to ensure the applicability of and implementation of the legal acts?
Sorry, can you say that again?
If you are also investigating and doing controls to the official bodies, the public organisms that are in the member states, have the responsibility to ensure the implementation of the legal acts?
Well, normally that's the legislature itself, so yes, it's part of our job for that. I hope that answers your question nice and simply. Is this one?
Yeah, and just like Birgit mentioned as well, that the case with the meat in Iceland, that was exactly that they didn't change the law, so that's the official body, of course. Yep, over here.
Hi, my name is Sasha from the UK. I had a quick question. What's the volume of cases that you're dealing with on an annual basis, and how many of those are direct action, for example?
To the court, then. Yeah.
I'm guessing it differs a little bit. We've had, on average, I'd say between 10 and 20 cases. It's, the caseload isn't very high. I mean, like I said, we're only 20 people. On average, I would say we have between 10 to 15 substantive cases. So which are either substantive direct actions where they're contested or requests for an advisory opinion. Very often we've had like record years with 36 cases in 2015. Of course, like half of those were rubber stamp cases. So, so very often, like you have this sort of this bump around like the years after the crisis, when like a few years after. So like maybe from 2013-14 until now 2017, I guess. You have this bump, you have this increase in caseload, but a lot of that are Icelandic rubber stamp cases. So it's probably the statistics.
You want to add something to statistics?
No, just to say that, like I was saying in my presentation, bringing cases before the EFTA court is one element in the toolbox. So the fact that there are more or less cases doesn't necessarily reflect the whole picture. You have to, and this is why we do the lecture together, you have to look at the surveillance and court mechanism as a whole. So potentially on a year where you've got a whole bunch of cases at the EFTA court on a particular thing, that's because ESSA couldn't manage to persuade the member states, for example, to resolve a particular issue. So the number of cases is a reasonable measure, but it's by no means the whole picture. You have to look at the number of cases coming into ESSA as well, and then the pathway through which those cases are resolved, whether that's the court or whether it's changes in the legislation, which could be super simple or could be really difficult and complicated and take a lot of time. For example, if you're looking at the financial services legislation, there was a huge amount of discussion, even how to make that type of legislation fit the EEA institutional structure. It's complicated legislation. You might find that in 3-5 years' time, ESSA is dealing with a lot of that. But the structures that we have in place are pretty good, so maybe then they won't lead to court cases, but it doesn't mean that there isn't work going on in those areas. So I hope that that kind of also adds another perspective into that way of measuring things.
All right. More questions? Yep. Over here.
We have seen on one of the slides, we have seen the slides several times, that some of the subjects are exempted from EFTA legislation, like agriculture, trade, things like those. As you mentioned and you explained later, of course, sometimes there's a border goes from both sides, and so there was food security control and animal welfare control, which is in fact a part of agriculture. Are there other subjects that also are made smaller in practice, so that is not the full exemption for trade or for defense or for whatever, because there are other fields that, well, eat a little bit from it?
That's mostly why we use the agriculture food thing as a part of that. So that basically we use that example because that's the one where it is most important. There are some fields which have links to other fields. So for example, I guess maritime security would have some links to the kind of the general security and external action, but these are more the people that we might end up talking to rather than taking kind of any sort of competence in that area. So for the rest, it's pretty well defined.
All right. Further questions to either of them?
Everyone's hungry.
Yeah, I know. Yeah, okay. So, of course, all the presentations will be given to you online. So, thanks to both of you. Now we break for lunch, and we resume again in 1 hour at 1:30. We have 3 more very interesting stuff to talk about.